Hello and welcome to this talk about 0 hours contracts. I'm going to talk about the exclusivity terms of these contracts and the new rights that have just come into effect. My name's Declan O'Dempsey. I'm a barrister at Cloisters Chambers. What is a 0 hours contract? In law, Section 27A of the Employment Rights Act says that it's a contract of employment or other workers' contract under which the undertaking to do work or perform services is conditional on the employer making work or services available to the worker. Secondly, there is no certainty that any such work or services will be made available to the worker. So there are two aspects of that which may be of interest. The Act stipulates that an employer makes work or services available to the worker if the employer requests or requires the worker to do the work or perform the services. So this will lead to questions of when an employer makes a request or requires the worker. The other aspect of interest is the question of certainty. This is a very high standard. If there's any doubt at all as to whether work will be made available, clearly there is no certainty. The 1996 Employment Rights Act, in Section 27 capital A, states that if the contract is a 0 hours contract, then any clause which purports to prevent you from carrying out work under another contract or under another work arrangement, or if it prohibits you from carrying out these activities without the employer's consent, then it's unenforceable as against the worker or employee. And this is significant because if you're dismissed or exposed to detriment because of breaching one of these purported terms, then the regulations give you redress. When determining whether somebody is an employee for the purposes of having rights under the 1996 Act, exclusivity clauses are not to be considered unenforceable. So they're not unenforceable for determining any question whether a contract is a contract of employment or whether it's a workers' contract. So exclusivity can remain a factor in favour of a finding that the person is an employee, but the Act makes it clear that the exclusivity clause cannot be relied upon by the employer. In that sense, the clause is unenforceable. The Act also covers non-contractual arrangements. So it deals with non-contractual 0 hours working arrangements. This is an arrangement which isn't a worker's contract under which the employer and an individual agree on terms on which the individual will do any work where the employer makes it available to the individual and where the individual agrees to do it, but under which the employer is not required to make any work available to the individual, and under which the individual is not required to accept the work. It's only for these purposes that the person who is giving the work is regarded as an employer. In relation to these non-contractual 0 hours arrangements, the that person is to be treated as an employer. And this is despite the fact that the arrangement would not ordinarily constitute employment. The employer for these purposes is not, by reason of this, regarded as an employer for other purposes. The regulations which give redress are the exclusivity terms in 0 hours contract redress regulations of 2015. They provide for employees to have the right not to be unfairly dismissed for certain reasons, for employees and workers to have the right not to be subjected to detriments for the same reason, and for workers not to be subjected to the detriment of having their work terminated, so that's non-employees. The regulations also make provision for remedies and time limits relating to breaches. So first of all, the regulations under Regulation 2 make provision for unfair dismissal of employees who are under 0 hours contracts. So an employee who works under a 0 hours contract is to be regarded, for the purposes of the unfair dismissal provisions of the 1996 Act, as unfairly dismissed if the reason, or if there's more than one, the principal reason for the dismissal is that the worker breached a provision or purported provision of the 0 hours contract which is rendered unenforceable because it's an exclusivity term. The regulations also make provision for the right of redress if you're subjected to detriments. So a worker who works under a 0 hours contract has the right not to be subjected to any detriment by or as a result of any act or any deliberate failure to act of an employer which is done for the reason that the worker breached a provision or purported provision of the 0 hours contract which is rendered unenforceable as being an exclusivity clause. Regulation 2.4 deals with the detriment of dismissal. Now, if the detriment amounts to the dismissal of an employee within the meaning of the unfair dismissal provisions of the 1996 Act, then the individual cannot complain of it as a detriment. That's because they can bring a claim under the unfair dismissal provisions in the ordinary way. However, if the worker is not also an employee, because you can be both, then the detriment will not amount to the dismissal of an employee for the purposes of the unfair dismissal provisions of the 1996 Act, and in those circumstances the worker can claim for having their contract or arrangement terminated, and that is regarded as a detriment. There's no qualification period for a claim relating to detriment. There's no qualification period for the purposes of dismissal of an employee for these reasons. So in the case of dismissal because of a breach of an exclusivity clause, there's no qualifying period, and that means that on day one, if the employer sacks you because you want to work that day for somebody else, then you would be able to bring a claim for unfair dismissal as an employee, or if you're not an employee, you can bring a claim for the detriment of having your contract or working arrangement terminated. The regulations provide for complaints to be made to the Employment Tribunal. An employee can present a claim for unfair dismissal to a tribunal in the usual way. Regulation 3, however, provides that a worker may present a complaint to an employment tribunal that an employer has infringed the right conferred on them not to be subjected to a detriment for a 0 hours contract exclusivity clause related reason. The time limits. An employment tribunal mustn't consider a complaint by a worker for a detriment unless it's presented before the end of the period of 3 months beginning with the date of the act or failure to act to which the complaint relates, or where that failure or that act is part of a series of similar acts or failures, the last of them. However, the Employment Tribunal may consider this type of complaint, which is presented outside the time limit, if in all the circumstances of the case it considers that it's just and equitable to do so. Notice that for unfair dismissal under the Employment Rights Act 1996, the principle allowing the tribunal to extend this time limit is much more difficult to satisfy. It's only available if it wasn't reasonably practicable to present the claim within 3 months. You should also notice that a worker is required to go through the early conciliation requirements with ACAS, and those early conciliation provisions may extend the primary time limits in these cases. For the purposes of claims of detriment, if an act extends over a period, the date of the act means the last day of that period. A failure to do something is treated as occurring when the person in question decided on it, and in the absence of evidence to the contrary, that person is taken to decide on a failure to do something when they do an act inconsistent with doing it, or if they don't do an inconsistent act, on the expiry of the period in which they might reasonably have been expected to do it. In relation to complaints of detriment, the regulations also stipulate that if the worker presents a complaint of this nature, it's up to the employer to identify the ground or the reason on which any act or deliberate failure to act was done. So in other words, the burden of proof is shifted to the employer to identify the reason for any act or deliberate failure to act which is challenged by the complaint. The regulations also provide for remedies, and these are a declaration as to rights. They can order compensation, and the amount of the compensation has to be such as the tribunal considers just and equitable in all the circumstances, having regard to the infringement to which the complaint relates, and any loss which is attributable to the act or failure to act which infringed the complainant's rights. Losses are taken to include any expenses reasonably incurred by the complainant, but these must be in consequence of the act or failure to act to which the complaint relates. Loss also includes loss of any benefit which the complainant might reasonably have been expected to have but for that act or failure to act. Finally, the tribunals apply the concepts of mitigation and of loss and contributory fault. So they apply the rule that the claimant must not take unreasonable steps, either to increase or unreasonably to fail to lessen his losses. It's important to remember that the proof of being unreasonable is on the employer. It's not for the victim of the wrong to show that they acted reasonably. Secondly, if the detriment to which the worker is subjected is the termination of the worker's contract, but it isn't a contract of employment, then the rules for calculating the basic award and the compensatory element are applied to that worker's loss as if they were an employee claiming unfair dismissal. And this includes the draconian cap on the compensatory element under section 124 1ZA of the 1996 Act. Finally, if the tribunal finds that the act or failure to act to which the complaint relates was to any extent caused or contributed to by action of the complainant, it must reduce the amount of the compensation by such proportion as it considers just and equitable, having regard to that finding of contributory fault. Thank you very much.